There you go. See less of
right.
it.
Is that better?
Just a second.
Yeah.
Go ahead.
Happy New Year to all our viewers and welcome to 2021 at the Explorers Club. We're starting off this season with a world premiere of a new series called Explorers and the Law. Explorers today are faced with many challenges, among them legal issues out in the field. We put together a very special panel of lawyers specializing in all aspects of exploration law. Their cumulative experience in this field and on expeditions together is nearly a century, and they are all members of the Explorers Club. Here for our very first program are David Concannon, Charles Norchi, and Kristin Larson to give you a background on exploration law. Take it away, Charles.
Thank you very much, Anne. So just to set the stage a little bit, my name is Charles Norchi, as Anne indicated. I am a law professor, but I've been a lawyer, legal scholar for a long time and a long-standing member of the Explorers Club, having carried the flag on multiple expeditions. I'll be setting the stage tonight with my friends and colleagues. I'll talk a little bit about why explorers need to think about the law, how expeditions have changed from a previous age until our current age, why that is, and why this kind of topic is important for all of us. Kristin?
Hi, I am an Antarctican first, with a couple degrees in science. I got my law degree actually about 20 years ago, and I've been practicing ever since. My focus tonight is to share with you kind of a mysterious death that happened in Antarctica as a way of illustrating really all the ways that the Antarctic Treaty works and in some ways how it doesn't work to produce sort of satisfactory results in the law. So that's it.
Hi, my name is David Concannon. I've been a lawyer for about 30 years, member of the Explorers Club for 25. I have a company called Explorer Consulting, which is the business of exploration. I don't know how many expeditions I've been on, how many expeditions I've advised, a lot. There's always 2 or 3 a year that are going into the field. Primarily, I just solve problems and I try to think around corners and see what problems are going to arise and how to anticipate them. And when you get into trouble, I help you get out of trouble. So my talk tonight is going to be focused primarily on space and sea, 2 areas where there isn't a lot of law and where I'm often asked, can I do this? And the answer is often yes, because there's nobody there to tell you can't. So I'll just get into that a little bit and look forward to presenting with these distinguished colleagues of mine. Thank you.
Excellent. So with that, I would like to set the stage, as I just said. I'm going to try and share a screen with you. So our session tonight is Explorers and the Law, as Anne indicated to us, and thank you all of you for being here, wherever you are in the world. And we've conceived this actually as a series. So we are thinking that this will be the first of a number of such sessions where lawyers and expedition leaders and expedition planners will get together and think about the kinds of problems that they face with respect to expedition planning and the law. Expeditions have context, and I like to think of them as the who. Are you a scientific society like the Explorers Club? Are you a university, such as where I work? A corporation? Are you a group of friends getting together to put together an expedition, as many of our members in the club do? Are you a social group? And then there's the why. Why are you putting this expedition together? And this has, of course, changed over time, over centuries. Discovery, knowledge, which is primarily the key reason these days. Reputation, wealth, power in an earlier age of exploration. And where? Is your expedition going to be on land, on sea, airspace, outer space? What will you be doing? what kind of activity? Trekking, climbing, diving, flying a drone, flying a plane, sailing. Will you be collecting and sampling? Each of these activities, this who, why, where, and what, gets you to think about the kinds of legal considerations you need to have in mind as you have your expedition goals in mind. These can be such concerns as the permits that we all think about when we put our expeditions together. So national regulations, particularly if we're going abroad, or even within the United States, if you're in our state park system, there's a vast regulatory set of requirements. You may have international law in mind, the UN Convention on the Law of the Sea, underwater cultural heritage, etc. You might have jurisdictional questions in mind. You may have contract issues at the planning stage. You'll be thinking of insurance if you're bringing back specimens, export-import concerns, if you're involved in salvage, maritime law, possibly intellectual property, criminal law, which you'll hear about. And in some societies certainly where I work, because I do a lot of legal anthropology, customary law, the kinds of legal arrangements that traditional societies and indigenous peoples find are most important that must be respected. And non-compliance can bring risks of fines, delays, arrest, litigation. And then the context and the conditions evolve. Funding can evolve. The weather evolves. War, civil unrest, some of the expeditions that I've been involved in. And then, of course, pandemic is affecting so much of what we do. Universities, foundations like the National Science Foundation, and again, the scientific societies such as the Explorers Club, the National Geographic Society, the Royal Geographic Society in London, think about these kinds of issues a lot. Expeditions before our age of compliance were very, very different. There was a time when expedition planners didn't need to think about much of this. If we think about some of the great early explorers in our club, one of the firsts to the North Pole, Robert Parry I quite like because he's also from Maine. Parry and Matthew Henson reaching the pole. Cook, who had claimed to reach the pole. But this scramble for the Arctic was a time of terra nullius, the notion that land, territory, was inhabited by no one and open for discovery and conquest. This was a period of ineffective legal systems. There were few international legal standards, no permitting requirements, no environmental safeguards, no protections for indigenous populations. Exploration was near frictionless. It was nearly frictionless because there was so little law. And there was uneven respect for places and people. This has changed. This has changed as exploration has changed. So we've come from an era of pre-compliance to what we have now, which is our age of compliance. And I like to think back to Gertrude Bell. Gertrude Bell with Lawrence Arabia, connected to Lowell Thomas, a lot of Explorers Club, World Geographic Society connections. After the First World War in Mesopotamia, Gertrude Bell, who was an extraordinary woman, was appointed Director of Antiquities by King Faisal. And what did she do? She was very much concerned about foreign expeditions coming in and removing artifacts from what would become Iraq. So she drafted the 1922 Antiquities Act of Iraq, one of the very, very first compliance regulations, and henceforth, foreign expeditions require permits. This trend moves across the Middle East, Central Asia, other countries. And so that means that today, good for us and good for the places that we explore, good for contributing to knowledge, good for protecting local populations and places and the environment, we now are in an age of compliance. I thought I would touch briefly on a couple of expeditions that I've done. One was, the first one that I'll talk about was in Afghanistan in the 1990s, 1994, if I'm correct. It was flag number 155, and it was a very different context. And the point I want to make here is that expedition contexts vary greatly. This was a situation, I reported this at a presentation at the club a couple of years ago on this very expedition. We were working in the context of a fragile state. The essential law that was applicable in an area of low intensity conflict or pockets of armed conflict across the country in areas where we were working were the customary codes and their practices. If you wanted a permit, you didn't go to the government, you didn't go to the central government. If you were working in the countryside, you went to local commanders, to elders, and to mullahs. And we were working at this point on the problem of the protection of cultural property during a time of armed conflict. So there was an international law that we were paying attention to. It was the UNESCO Hague Convention on the Protection of Cultural Property. Some of you might have heard the late Nancy Dupre, the great anthropologist, speak at the Explorers Club and at the Asia Society. We were working with her on the protection of the looted Kabul Museum at the time. And then in this context, international human rights came into play too. But this was an expedition where the whole set of compliance and legal issues that one thinks about working in a fluid, fragile state is very, very different than this next expedition that I would like to tell you a little bit about, just by way of comparison. A couple of years ago, we had flag number 136 for ongoing work that we do in the Arctic. When I say we, now this is different because this was a university group of sciences. My co-lead on this was Professor Paul or Dr. Paul Majewski, who's a fellow and medalist of the Explorers Club. He chairs the Climate Change Institute. And we have been working on the intersection of law and science in a way to enhance expeditionary law training for students and to support the scientists. And so we've had a program of these expeditions, this work, particularly in Greenland. Now, this particular expedition did not have students along. We had 16 scientists. We had scientists, we had physical scientists, biological scientists, anthropologists, every scientist you can think about, every sort of scientist you can think about who works in the Arctic other than an atmospheric scientist. But we had everything else. Now, what regulations and laws were we thinking about? Well, there was all the permitting. If you think about all of those scientists and the kinds of things they need, Greenland, which is part of Denmark, but Greenland has its own regulatory and compliance requirements and a central location where you can go with the government, to the government, and you do all of the compliance work, depending on whether you're going to be doing archaeology, core samples from ice, other kinds of specimens. And because this was a science expedition, we were working on permitting across a number of disciplines. The site of this particular expedition was a World Heritage Site called Kujata in southern Greenland, southwest Greenland. And these World Heritage Sites in Greenland are under the auspices of the museum. So we were working in terms of permitting with the National Museum of Greenland, famous for the mummy collection they have, and there's one of the mummies on the cover of that National Geographic, to help preserve this site in an area of climate change, in an era of climate change. The other set of regulations that we had to think about, there's an agreement on enhancing international Arctic scientific cooperation. So this agreement is in place to protect and to enhance sharing of scientific information through the Arctic Council. It's an Arctic Council Treaty agreement, and this was another sort of a law that particular expedition had to think about. And then a context that was the driver of this whole thing, and this is a place where we plan to go back to this summer, but it is totally on hold because of the pandemic. We were first on this expedition in 2019. Last summer it was canceled because of the pandemic, and this summer is unclear as well. But climate change very much was the driving context for what we're doing there. So if you think about these two examples of expeditions, Afghanistan, a war zone, right? A fragile state, minimal regulations. Greenland, part of the Danish realm, different kinds of issues, different kinds of problems. Greenland, by the way, is an indigenous population. Almost the entire population is indigenous. So everything that we did in Greenland also involved interacting with the Inuit Circumpolar Council and indigenous peoples' laws and rights. So here you see two expeditions, very, very different, two different concerns with respect to the law. And in this particular one, climate change, I should give a shout out to Alexandra Moore, member of the club, and again, Paul Majewski, fellow of the club. The three of us put this website together with the lead of Paul and Alexandra, to be frank, on whyclimatematters.com. And I can recommend that to you, for those of you following this. So, our club, something to think about, and I'm trying to tee this up a little bit for the future. We have a code of ethics at the Explorers Club, and I know David's going to touch on some of this. We are an organization dedicated to the advancement of exploration and scientific inquiry. We're not a travelers club. The obligation that the explorers, particularly an explorer that has this flag, which means something very, very specific. The obligation includes acquiring new information, reporting activities, disseminating new knowledge. We're not treasure hunters. That's point number one. Number two, respect for the environment and local culture, leaving them undisturbed and recognizing that the explorer is the foreigner and a guest. Contrast that to the earlier age of exploration, pre-compliance. You would not have seen this kind of a document in any of our organizations, certainly before the First World War, probably not before the Second World War. Point number three, and this is a driver in this series, Explorers in the Law, respect local, national, and international laws. Give full credit to others and plan. And so this will be a topic of a future Explorers in the Law session when we talk about expedition planning and the law with respect to specific expeditions being organized by the fellowship, by the fellows and members of our club. So, do I need a lawyer? Should I consult my lawyer? I leave you with that. And if anybody wishes to be in touch with me, come to Maine. We have good lobsters here. That's my email. And I'm going to stop there and hand it over to Kristin.
Good evening. So good to be back with all of you. It's been a while since I've been on the East Coast and enjoyed your company in person. Before I get launched into Antarctica, I want to give a very, very warm and heartfelt thanks to Ann Passer and the lecture committee. I think that these lectures have taken on a whole new profound importance for all of us explorers as we've sort of hunkered down waiting for this COVID pandemic storm to pass over. And, it's actually, especially for someone who's been on the West Coast and sort of isolated from what's going on at headquarters, all of a sudden there's just like this fantastic new venue for connecting and staying inspired and hearing about all of our fascinating members. So, I just can't say thank you enough. And I'm very pleased and privileged to have been asked to participate. Okay, so tonight I'm going to tell you a scary story, partly because that's what explorers do. We love to tell our stories. We love maybe to tell a story that involves a death, and a mystery. This particular story takes place on the Antarctic Plateau in the midst of a bone-breakingly cold South Pole winter. It involves a death. that remains unsolved and unadjudicated. And it's a death that there are still some suspicions was a murder. So bundle up, sit close, but because we're talking about the law, I need to tell you a little bit of the backstory. And that, is sort of a topic that involves giving you the governance structure and the legal framework that governs the continent of Antarctica, which is very different and unique. But you'll hear from David and others that it's a model that's sort of being looked at and applied sort of more universally. So I'm going to tell you a little bit about the Antarctic Treaty, how it came to be, and how it affects day-to-day life. So let's go bipolar. What the heck? What I'm not going to do is, go into a lot of detail about, the differences and the similarities of our polar regions. In truth, there's probably a lot more differences than there are similarities. Superficially, they seem, alike, but they're really not. The thing I want to focus on is that of human occupation. There's a big difference there. The Arctic has recorded human occupation that goes back 40,000 years. It's in Western Siberia where there's been artifacts found. This stands in extremely stark contrast to Antarctica, which no one actually was known to have seen even the continent until the mid 1800s. And the first footsteps on the continent itself are thought to have occurred around 1895. So if you think about that, I mean, that's like our great-grandparents or maybe our great-great-grandparents were around when a whole continent the size of Mexico and the U.S. combined, big continent, had never had human footprints on it until, just 2 or 3 generations ago. I think that's a pretty remarkable fact. Maybe equally remarkable is that we did not waste any time sort of making claims and exploring this terra nullius, as it were. In the period between 1908 and 1943, 7 different countries made territorial claims to the continent. You can see that at least 3 of the claims are overlapping in the peninsula. And, some of the claims like Norway are sort of incomplete, and the bases for these claims is all over the map, so to speak. Some said, well, we planted the flag, a very traditional method. Some say, well, there's a continuity between the Andes and the Transantarctic Mountains, so therefore it's part of our country. So anyway, that's a whole topic for another discussion. But the point being is that, and I think that the very important point for our purposes today is that there were claims, and there was the beginnings of major diplomatic skirmishes about the legitimacy of these claims, and it was really getting heated up at the Cold War. We've been heated up at the Cold War. It was really escalating, and primarily between the USSR and the United States, who were sort of saying, well, we've established bases and a presence that could sort of take over the whole continent. We have a basis for that. Anyway, the collateral damage from these diplomatic skirmishes was the science programs. It was discovered, that, in this period that really the polar regions are remarkable laboratories for understanding our Earth. And, atmospheric processes, ocean processes, plate tectonics, whole host of really important scientific investigations were kind of in their infancy when all of this, strife was going on. And, as Charles pointed out, like what's going on in the Arctic right now, and they've put together this agreement on the enhancement for scientific cooperation. Well, that's really what the scientists were asking for. In the view of the scientists, they said, well, the emperor penguins really have it right. It doesn't make sense to have territorial claims. It's expensive. It's logistically difficult. You have to guard them. It's much better if you just sort of huddle together and cooperate. And, believe it or not, the government's, bought into this scenario. And it resulted in probably what still stands as the most remarkable collaboration among scientists ever. And that was the International Geophysical Year that happened between 1957 and 1958. Side note, this was the third such collaboration, the other two happening exclusively in the polar regions and actually involving the founders. The very first one involved the founders of the Explorers Club. But that's, again, a different topic, different lecture. For our purposes today, it's important to note that there was 12 different countries that were working all around the Antarctic continent, and they had actually established 44 different stations, which in itself is an amazing feat. This is a little off topic, but I would be remiss if I did not make note that today, this very day, is the 63rd anniversary of our very own honorary chairman, Ed Hillary, reaching the South Pole as part of the IGY. He ran half of the Trans-Antarctic expedition, Vivian Fuchs, of course, the other half, and they were the first to do a full transect of the Antarctic continent. Remember, size of the US and Mexico combined, so big deal. And they collected a lot of really important science along the way and accomplished what Shackleton was not able to do 50 years prior. Quick shout out, if this is a topic that you love, like I do, ask Angela for the spring 2007 edition of the Explorers Journal, because I go into great depth on all of our great members who've been major contributors to these huge international scientific collaborations. Okay, so the IGY provided a really important springboard for the establishment of the Antarctic Treaty. It was so successful, and the scientists really, I think, kind of won the day and said, look, quit fighting. Let's just agree to disagree. And for our purposes today, the most important part of the Antarctic Treaty was regarding those 7 claims that were there. Remember, there was all these different claims. So what the treaty did was it didn't deny the legitimacy of those claims, but it did not endorse them either. It said, we're going to put them in a Tupperware, we're going to put them in the refrigerator, and we're just not going to talk about it for a while. You can't enhance your claims, but, they're, quote, frozen, as it were. So that was just kind of like really novel. No other treaty in my understanding has ever been able to accomplish this. And quite frankly, no one thought that it would survive very long. So these are the original parties. And so there was the 7 that are shown in blue of the original claimants. And then there's 5 more that had the substantial presence during the IGY. And lo and behold, here we are, how many years later? 60, 55 years later. And now we have, how many? We have 54 members, and those 54 signatories collectively represent 80% of the human population on Earth. So I would say that this experiment so far has proven to be very successful. And there's a lot of countries. The ones in red are ones that actually have an active and ongoing presence on the continent. And it's expensive to, to field scientists and support field work and stations in Antarctica. So it's a pretty big commitment to the success of this very unusual legal framework. Okay, so let's just kind of, repackage. I know I'm talking fast because, I don't want to get the virtual shepherd's hook. So let me just say, we, have now arrived at the doorstep of modern day Antarctica. In the scant 150 years, plus or minus, we went from not a single person on the continent to this major presence and interest in the continent. But, you know, how does this really play out, you know, in day-to-day, you know, on a day-to-day basis? You have thousands of people coming and going off the continent now to do science and maintain the stations. You know, the Antarctic Treaty really kind of addressed the thorny issues of territorial claims and sort of resource protection. But, you know, there's no courts, there's no prisons, there's no police force. You know, what happens, you know, when you know, we stop singing Kumbaya and something bad happens? Add a little alcohol to that, add a little circadian rhythms messing up because of the light and dark, add to that isolation, and guess what? You know, you do have a few problems. But surprisingly, I think everyone, I think, would be sort of surprised to, you know, that there really are relatively few deaths that occur in Antarctica. I mean, when they do, it's kind of you know, international news. And mostly it has to do with aircraft crashes. You know, occasionally people fall into crevasses. But there's even fewer crimes and violent behavior. But, you know, it does happen. So you know, when there is this sort of an event, you know, how does it play out? And I think that that's really where sort of the test of the Antarctic Treaty and the territorial claims and the conflict of laws really kind of come into play. And it's important, you know, it's also interesting, I guess, if you're a lawyer, to sort of understand how all those things sort of come together and, you know, or how they don't come together. I'm not going to go into a lot of detail about, you know, some of the gnarly, you know, murders and that sort of thing that have happened down there. But, you know, there has been a few. I think my favorite, if I can say a favorite, happened at Vostok Station, which at the time was still part of the USSR. That was in 1959. Basically, when the Antarctic Treaty was just in its infancy. You know, one scientist murdered another scientist because he lost a chess game. You know what? They then immediately said no more chess can be played at any Russian USSR station, but they still allow ice axes and plenty of alcohol. So you can see what the priorities are. You know, there's been some hammer fights. A couple different people have burned down parts of stations hoping to get off the ice early, and guess what? It worked. They did get off the ice early and went right to jail. And most recently, where this picture was taken, 2018, in Bellinghausen Station, which is also Russian. One person stabbed another, repeatedly in the chest. Remarkably, he lived, and supposedly the reason was because the victim kept giving away the endings of stories that the other one was reading. So, you know, it can be a little dicey if you're kind of locked up with, you know, some kind of crazies. I think the important thing to note, though, with all of these examples, they didn't cause any significant diplomatic stress. Or, you know, and the resolution was straightforward because they were, you know, for instance, in the Russian stations, it was a Russian, you know, against a Russian at a Russian station. And so it was a very clean, clear-cut case where, you know, it was, you know, sort of contained within the nationality. There was no cross-cutting territorial claims. So I think, you know, that is where sort of the rubber meets the road. And that's where our little story at the South Pole comes in. So, are you ready? Once upon a time, in a place that was minus 80 most of the time, and very, very dark, at least half of the time, our guy, an affable Australian PhD astrophysicist, can be seen shuffling and wobbling a bit as he crosses the icy terrain between the telescope building and the main base, both of which are improbably situated on top of a 10,000-foot ice cap. His name is Rodney, and he is 32 years old. Rodney is one of those unusual humans that actually loves being part of the weird winter over community which forms during a South Pole winter. He liked it so much the first time, just the year before, that he went out of his way to secure a new and different job for a second winter, directly on the heels of the first. Pretty crazy. Despite his predilections for dark isolation, Rodney is not an awkward introvert. He is friendly, he likes to party with the small, tightly knit community of 50, and he even plays music in the bass rock band, Fanny Pack and the Big Nancy Boys. And he has a girlfriend too. Her name is Sonia, a base maintenance specialist, and they are just starting to plan their marriage. Rodney feels dizzy and wretched, and his eyes are suddenly so sensitive he cannot look at any of the lights. But it wasn't the high altitude that was bothering Rodney. He was really used to that. And he wasn't getting sick from a cold or the flu because winter over isolation acts as a complete barrier to new vectors. So Rodney decides to go to bed early. But the next morning he wakes feeling even worse. Now he has burning pain shooting through his joints and his stomach. He has to wear sunglasses, and then he starts vomiting blood. Ugh. By the third visit to the base medic that day, Rodney is hyperventilating. The doctor thinks Rodney may be having a nervous breakdown, and he administers an antipsychotic. This indeed calms Rodney down right away. But soon he stops breathing altogether and quickly goes into cardiac arrest. The doctor pronounces Rodney dead and proclaims he died of, quote, natural causes. His friends and colleagues are obviously distressed, and they face the daunting prospect, with 6 months remaining until a flight can safely land at the South Pole. There'll be no place to put their friend to rest. And maybe just as importantly, there's no way to verify the mysterious cause of his death. It hardly seemed natural. So finally, in October, a plane transports Rodney's body, which was preserved, by the natural minus 70 degrees outside, to Christchurch, New Zealand, which is, the closest sort of civilized spot. It's also the logistics hub for the U.S. South Pole stations and McMurdo Base, and also for New Zealand's Scott Base, which is near McMurdo. The Kiwi forensic pathologist, Dr. Sage, great name, right? Who performed the autopsy, directly contradicts the South Pole doctor's finding of natural causes. Instead, he discovers that Rodney was poisoned to death by methanol, and adds that he must have ingested more than a full cup of the poison. For those of you who don't know, methanol is a type of alcohol that's used to clean scientific equipment. It's nearly tasteless, it's clear, but extremely toxic, even in small amounts. So, little other evidence was produced to help understand how the methanol got into Rodney's body. It was ruled out that it was basically ruled out. Nothing is really ruled out altogether because there's so little evidence, but it's considered to be highly unlikely that he drank the methanol by accident. He uses it scientifically. So, he probably didn't, just accidentally drink it. And he probably did not drink it experimentally. There was plenty of drinkable ethanol type alcohol on the base, which he was well known to imbibe. Did he commit suicide? That's unlikely. Why would he go to the doctor? He had the prospect of his marriage. His career was, just taking off. So if you dismiss those possibilities, though, that only leaves one explanation, that he was murdered. And that means the poisoner continued undetected for another 6 months of isolation and remains free to this day, 10 years after committing this crime. And there's also some that say that the South Pole doctor's response is ultimately what killed Rodney. Allegedly, he did not use some of the tools that were at his disposal that may have allowed a more accurate diagnosis and response. Anyway, after 8 years of inquest, in 2008, the case went cold. There was just not enough evidence to establish key facts. And the coroner, put in his report that he could not rule out foul play. So, what can we learn about the Antarctic legal system from this sad story? Well, first and foremost, the approach to the investigation demonstrated very clearly how territorial disputes and claims of legal jurisdiction can butt up against each other in Antarctica and produce really unsatisfying results for the victim or the victim's families. As pointed out earlier, in a very simplistic situation where you have Russian versus a Russian at a Russian base, the results are very clear and justice will probably be served. But here we have an Australian national dying of mysterious, circumstances at a U.S. base that is ostensibly located in a sector of Antarctica claimed to be part of the New Zealand Commonwealth. Reportedly, and I'm not saying for sure, the U.S. National Science Foundation, who administers the South Pole, was, reportedly not that forthcoming, with the investigation. And they're my former employer, disclaimer. But they flatly deny that characterization. There was very little evidence that could be gathered from Rodney's workplace that could, shed any light on it. There was a voluntary questionnaire that was given to all of the winter overs. Only 13 ended up, filling it out as voluntary. So anyway, 20 years after these facts played out, there was really no justice done, and the family of Rodney and his friends, are left basically, sort of perplexed, is I guess to put it lightly. I'm just going to kind of sum up real quick. This is a very wordy slide, and no need to look at it in any detail, but the application, the extraterritorial application of U.S. law is really spotty, and it's all over the place. And it seems, from my perspective, to be kind of cherry picked to sort of promote the U.S. interest rather than sort of promote the interests of, citizens of the U.S. On the stations, or even if you're on expedition, so the criminal law is pretty clear. The case law is pretty settled on that. A lot of it stems from, I think this is a particularly interesting point, from what we'll call embassy law. So embassies are like little islands of U.S. jurisdiction, so as long as you're inside the embassy, even though you're in a foreign country and a crime gets committed, you're going to probably have federal criminal law applied to you. So even though it's not directly analogous because, the U.S. stations are not really in a foreign country, for purposes of federal criminal law, it is treated like you're in a foreign country. And also the Federal Tort Claims Act. So let's say, the U.S. Plane crashes because of negligent, maintenance, or they didn't flag a route correctly and someone falls into a crevasse. These are not hypotheticals. These actually happen. Families sued the government and they said, nope, there's no reach for the Federal Tort Claims Act. So again, no satisfaction on that basis. However, if you earn money in Antarctica, hell no, it's not a foreign country. You are going to pay taxes. Labor laws, if you have overtime, oh no, it's a foreign country. We don't pay overtime in Antarctica. So, the law is really not clear cut on, what the outcome will be unless you, perhaps stab another American. Anyway, that's the story. I think I'm going to leave it there. Next up, we have David Concannon. He kind of already introduced himself, but I just want to say, this is my little introduction that I wrote. So personally, I think that a lawyer's job, first and foremost, is not to find all the reasons why your client can't or should not do something. in my personal practice, and you know, I feel that it's my job to help my client figure out how to get to his goals. And I have to say, David personifies this attitude more than any other lawyer I know. Once you hear some of his stories, you will certainly agree.
Wow. Thank you, Kristin, very, very much. Kristin, I've known Kristin forever, and she's a terrific person and a terrific legal practitioner. First of all, I have to apologize for my voice, little post-COVID fun. And secondly, I have to apologize for my slides. If you consider it to be death by PowerPoint for too much text, don't worry, I'll run through them quickly and try to give you an explanation. I have to say at the outset that my approach to the law and exploration is as a practitioner. I'm not an academic. I'm not a government employee. I admire these folks very much, but people come to me to solve problems. And the reason why I love what I do is because I get to put the puzzle pieces into place when you really can't see the whole puzzle, and you kind of have an idea what you want to do, but you don't really know how. And I'll let you in on a little secret. There are far more questions than answers when it comes to the law and exploration. You can ask me 100 questions and I can probably give you 3 answers today. And the reason is there's very little precedent, and the law revolves on precedent. There's very little custom, and the law depends on custom. And the truth is we're still figuring it out as we go along. And that would pretty much sum up my career in the law and exploration. And truthfully, most people that come to me with the first question they ask almost always is, can I do this? Can I do this? Not, can I climb this mountain, or can I go to this place in the ocean, or go to this place in space, but am I allowed to do this? Is there somebody to tell me that I can't? And the answer to that question is almost always yes, you can do this, because there's nobody to tell you can't. And I want to use the law of the sea and space as examples for that, because what Kristin just went through with the law of Antarctica is pretty much the most evolved legal regime we have about exploring in places that are remote and difficult to access, where governments don't have jurisdiction. And what we're seeing now in the age of exploration significantly is a shift from governments doing exploration to private enterprise doing exploration, private individuals doing exploration. And that is a game changer, and it is groundbreaking. And I want to use 2 examples to go through that, but let me share my screen and see if I can not screw this up. Again, apologize if this is too wordy, but I'll run through it quickly. So my piece on this tonight is Explorers in the Law, How to Navigate the Law of the Sea and Space, AKA the Wild West. And I say it's the Wild West because even though we have some laws, we don't have all agreement in all laws, and we really don't have uniform application. And even though some people will say you can't do something, the reality is you actually can. And do you need a lawyer? Yeah, unfortunately you do. But as I go through here, and I'll try to figure out how to advance the slides. You know, William Shakespeare said it best. First thing we do, let's kill all the lawyers. But my question to you is this really necessary? Even if it sounds like a good idea, who would keep you out of trouble? And more importantly, for our Explorers Club members, how would you comply with the Explorers Club Statement of Ethics, which includes an obligation of the explorer is to respect all laws, local, national, and international. There's only 5 statements of ethics of the Explorers Club, and this is the 3rd one. And what I want to talk about is what happens when there are no applicable laws. So one of my favorite quotes from any judicial decision ever, a venturesome minority will always be eager to get off on their own, and no obstacles should be placed in their path. Let them take risk, for God's sake. Let them get lost, sunburned, stranded, drowned, eaten by bears, buried alive under avalanches. This is the right and privilege of any free American. It's actually the right and privilege of any free citizen of the world. And this is a case in the matter of Gary Gentile, an Explorers Club member. Gary wanted to dive on the wreck of the USS Monitor in a national marine sanctuary. He was represented by Peter Hess, an Explorers Club member extraordinaire, one of the best lawyers I've ever known, and one of the best at finding ways to do things. Gary had asked the National Oceanic and Atmospheric Administration 11 times in 5 years for permission to scuba dive on the Monitor. And they consistently said no. If they said anything, often they said nothing. and they didn't answer his questions or issue a permit. At the same time, NOAA granted an identical application from the Cousteau Society in less than 30 days, and then they kept it a secret. They didn't say anything. So Gary went through the legal process of getting a judge to give him permission to explore a shipwreck in the Atlantic Ocean in an area that the United States had designated as a national marine sanctuary. And in the decision written by Judge Dolan, he quoted from that law review article from Idaho, of all places. And he poo-pooed the testimony of NOAA's witnesses and expressed concerns that it had expressed concerns for Gentile safety, saying the agency's witnesses, most of whom themselves are scuba divers, do not venture to such depths. However, they probably don't smoke, ride motorcycles, parachute, hang glide, scale mountain peaks, skydive, spelunk, drive speedboats, fish commercially, or engage in other activities permitted in society. So why am I telling you this now? Because the one thing you have to remember if you want to go into the field is that many of the people who have control over access and permitting have little or no experience doing the things that you want to do, that you are asking them for permission to do, and they can be biased. If you can give a permission to the Cousteau Society in 30 days, as Judge Dolan said, why can't you even answer Gary Gentile's questions? So here's an example. Question: is it legal to explore the wreck of the RMS Titanic without seeking permission from anyone? The answer is yes, as long as you're not David Attenborough, and I'll tell you why in a minute. But in reality, in 1999, the Explorers Club and other explorers won a lawsuit allowing unfettered access to the Titanic wreck site for exploration and photography. It's a case taken by the club and others, members of the club, all the way up to the United States Supreme Court. Full disclosure, I represented the Explorers Club and 3 of the explorers in that case. In 1999, the Supreme Court of the United States and the Fourth Circuit Court of Appeals said, yes, you can go there, you can explore, you can photograph, you can look at it, you can do anything you want, as long as you don't recover artifacts and salvage, because that right had already been given to another company. Since that time, however, serious legal obstacles seem to have been put in place of explorers trying to go to the Titanic. First, in 2001, the United Nations Educational, Scientific, and Cultural Organization, otherwise known as UNESCO, adopted its Convention on the Protection of Underwater Cultural Heritage, which protected any trace of human existence underwater for more than 100 years and set up a regime where governments could regulate access to underwater cultural heritage. Remember, this is any trace of human existence underwater for more than 100 years. Doesn't matter who owns it, doesn't matter where it is, it just says any trace of human existence. And according to UNESCO and proponents of UNESCO, the Titanic fell under the protections of the convention in 2012. And this is a story that's espoused all over the world, and it's espoused in the media. But you have to ask yourself, but did it really? In fact, the UNESCO convention entered into force in 2009, but has never been ratified by the United States, Canada, Great Britain, or any other really maritime nation. Therefore, it has no force of law in those places, not in the United States or anywhere else. It hasn't become customary international law, like the International Law of the Sea. The UNESCO Convention has been officially ratified by such important countries as the Islamic Republic of Iran, Niue, and Slovakia. So if you're citizens of these countries, you may have a problem with visiting the Titanic, but not necessarily. Because of that loophole, there was an effort to close it in another area, where the United States, Canada, France, and the United Kingdom negotiated an international agreement concerning the Titanic, where these governments, once the treaty became enforced, would regulate access to the wreck site, or so they said. The United Kingdom ratified the agreement in 2003. The United States signed the agreement in 2004, but it couldn't accept the treaty and put it into force. Actually, it's not a treaty, it's an agreement. There's an important distinction. Until implementing legislation had passed Congress. That's not a treaty. If it was a treaty, it would take 2/3 of the United States Senate for it to come into force. That's why the International Convention on the Law of the Sea has never come into force. And the United States hasn't signed it. The Senate won't ratify it. This is just a bilateral agreement. The UK accepted it in 2003 and said it doesn't come into force until the US accepts it. The US now says and enacted the necessary legislation in a funding bill for the Department of Commerce in 2017. This is how much money we're going to spend on weather. This is how much more money we're going to spend on satellites. And oh, by the way, in section 113, there's a couple sentences that say, no person shall conduct any research, exploration, salvage, or any activity at the Titanic, I'm paraphrasing, unless authorized by the Secretary of Commerce. There was no debate. There was no opportunity for public comment. There was no advisory committee set up. There was nothing published in the Code of Federal Regulations. This just happened. If you want to know why it happened, ask me in the questions. I'll give you the names of the two people that were responsible. Two, not the citizens of the United States, two people. But there's a loophole. Section 113 says only that a person must seek authorization. It doesn't say what happens if they do not seek authorization. It does not say that there's a penalty if you do not seek authorization. There are no penalties if you receive authorization from NOAA and you violate the terms of the authorization. And in fact, in 2019, the only expedition to ever seek Section 113 authorization violated the terms of the authorization by colliding with the Titanic. There was a NOAA representative on board the ship and they knew about the collision, but they never took any action except to conceal the collision from a federal court that was overseeing the salvage of the Titanic. NOAA never disclosed it to the federal court. It was disclosed months later after other people found out about it and brought it to the attention of the court. In January 2020, and you may have seen this in the news, the company with salvage rights to the Titanic asked the federal district court in Virginia that oversees the salvage under admiralty law for permission to cut into the wreck to recover the ship's Marconi wireless apparatus, calling it the voice of the Titanic. The company said to the court, we have no intention of asking NOAA for authorization to visit the wreck site. We have no intention of complying with Section 113. And in fact, we believe it's unconstitutional. Full disclosure, I represented RMST in this action at that time. The US government strenuously objected, citing the application of UNESCO, the international agreement, and Section 113. In the arguments over this case, I compared asking the proponents of UNESCO for permission to salvage the Titanic to asking the Taliban for permission to serve wine at a Catholic wedding. It really is that simple of a juxtaposition. And in May of 2020, the court granted RMS Titanic's request, and the expedition is scheduled to go forward in 2021. So you go back to the question, can I do this? The answer is yes. The reason why David Attenborough can't do it is because somewhere along the line, the British government thought that the US had enacted implementing legislation. So they went forward and enacted their law. And now if you're a British citizen, you can't go to the Titanic under penalty of criminal prosecution without permission from your government. So David Attenborough is precluded from going to the Titanic, but David Concannon is not. And I'll be going there on 2 expeditions coming up within the next year to 18 months. So that's the law of the sea. And that's where things are with the law of the sea. There are giant loopholes, and the law of the sea is really just meant to protect the coastal regions of a country and resource extraction, fisheries, and things like that. Otherwise, it's kind of open season. May not be entirely, but the reality is it is. Same thing goes really for the law of space exploration. And space exploration is really still the Wild West. But this past year, NASA seemed to be smarter than NOAA. NASA did something I thought was really clever. NASA wanted, and the United States government via NASA, wanted to set up a legal regime for exploration of the moon. And NASA announced that a handful of countries had advanced cooperation of exploration of the moon by signing something called the Artemis Accords. They didn't go through the United Nations. They didn't go through the European Space Agency. They didn't go through the normal way in which a treaty comes into force. Instead, the Artemis Accords talk about reinforcing and implementing the 1967 Outer Space Treaty, which if you read the treaty really just deals with the return of astronauts and space vehicles, not necessarily with exploration of the moon, because in 1967, nobody had been to the moon. We were hoping to go to the moon, and there was no precedent from which this treaty could develop. The Outer Space Treaty is a treaty that's been enacted by dozens of countries around the world, and it's an actual treaty, but it has gigantic loopholes. So what the Artemis Accords did, and their accords, was they filled in those loopholes, and the signatories to the Artemis Accords have agreed to certain tenets with a legal regime, such as preserving heritage, preserving the landing sites of the Apollo missions and the Soviet missions and others, and preserving outer space heritage, much like the Titanic Agreement was supposed to do, but the Artemis Accords actually incorporate that. The transparency, interoperability, emergency assistance, deconfliction of activities, what happens with orbital debris and the safe disposal of debris, and most importantly, ownership of intellectual property rights, which is what really pays for exploration these days, if it's private exploration and not taxpayer money. But the interesting thing about the Artemis Accords is there were only 8 founding member nations that have signed the Artemis Accords: Australia, Canada, Italy, Japan, Luxembourg, the United Arab Emirates, the United Kingdom, and the United States of America. And if you look at that list, how many of these countries have been to the moon or are going soon? So you ask yourself, well, what difference does this make? Why does this matter? How can this be enforceable? Look at the countries and organizations that have not signed the accords and have expressed their own willingness to do so: Russia, China, Germany, France, India. At least 3 of them have been to the moon or are going to the moon, and the European Space Agency. So how will these accords be enforceable? Well, that's why I said NASA was smarter than NOAA, because what they did, which was really clever from a lawyer standpoint, is that they decided to enforce these accords not by bureaucratic fiat, that's the COVID talking, but by contract. The Artemis Accords were born from NASA's Artemis program, which, if you've seen in the news lately, is intended to land astronauts on the moon, including the first woman, beginning in 2024. So they say. In reality, that's a big wish, because the Artemis program is dependent on the use of several systems, most notably the Space Launch System, or SLS, the Orion spacecraft, and the Gateway outpost in lunar orbit. It also depends, the viability depends on the priorities of the new Biden administration, securing necessary funding from Congress for huge budgetary shortfalls, and completion of the SLS rocket, which is woefully behind schedule, woefully expensive, it's not reusable. And when compared to like the Falcon 9, which is supposed to launch while we're talking, kind of a $68,000 hammer. But the one thing the Artemis program has already successfully achieved is a legal regime for exploration of the moon by those who are most likely to actually conduct exploration of the moon. How do they do that? Because NASA made the private companies that are participating in the Artemis program and getting US taxpayer dollars to develop human landers for the Artemis program, even if they're never used, to sign on to the Artemis Accords. And those companies are Blue Origin, SpaceX, and Dynetics, 2 of the 3 of which are most likely to go to the moon before any government does. Boeing is already part of the Artemis program due to its development of the SLS, so Boeing signed the Artemis Accords. So even if the Artemis program never flies, the contractual commitments will live on, and that means NASA just imposed a legal regime for exploration of the moon, even if the US government never sends another astronaut to the moon. And to me, that's a brilliant legal strategy, because we don't have jurisdiction over the moon. We don't have jurisdiction over Israel, France, Germany, Russia, India, China, but we do have jurisdiction over the private space exploration companies that are most likely to go there with or without taxpayer dollars. So to that I say, take that, William Shakespeare. Who do you think reads and writes contracts? Who do you think is creative enough to get the private entities who are most likely to go to the moon to agree to a set of legal standards for exploration of a place where the US has no jurisdiction? And who do you think has just secured full employment for themselves as explorers venture into the next decade and beyond? Lawyers. It's lawyers. You can't go out of the house without an attorney these days, especially if you want to go to some place where nobody has gone before. So thank you very much for listening. And that concludes my presentation. Oops. Does not conclude my inability to use technology. Cheers. Who's up?
So that was incredible, everyone. Thank you so much for all these incredible presentations. We certainly learned a lot from all of you tonight, and we have quite a few questions for everyone. So just to let you know a little bit of a background on how this started off, one of the members of the Explorers Club sent me an article about a murder on an ice sheet. His name is Dr. Hamanoff. And I read the article and I thought, wow, this is really fascinating. Well, I'd like to learn more about it. So I got in touch with the lawyers in front of you, and this turned into what we're hoping to be a series. And hopefully the next time around you see everyone, it'll be on how to plan expeditions so that you can ask your questions and what you need to know as an Explorers Club member, and how to proceed and how to do everything the right way. And my God, you're getting a bargain here because you got 3 of the best Explorers lawyers in the world. So I would take advantage of it and certainly write in. So our first question tonight, and a very happy New Year's to you, Jenny, is space missions are ongoing in the world. If there is a collision in space, heaven forbid, and the pieces of the debris fall on a territory other than the one where the spacecraft originated, how are tort lawsuits handled? Could you speak about space law liabilities? Are there limitations on liability, and what international organizations would be responsible for the application of space law in such a situation?
Want me to take that, Ann?
Absolutely.
Well, the Artemis Accords touch on it, what happens with space debris and who's responsible for it. And in fact, issues like dead satellites and where things fall to Earth is a pretty important issue. And there never was a legal regime to set it up. If a piece of a satellite fell on your head in Australia, technically you could go to court in Australia and sue the government that put that into space. But in reality, the government would probably have something called sovereign immunity, and you couldn't do that. So you were out of luck. And I'll go back to my original comment. There are far more questions than answers. We're developing answers to those questions as these problems start to come online. So I'll take a wild stab and say, I don't think that there's any legal precedent in this area. I think it's an issue that's becoming something that lawyers and judges and countries are thinking about, but it almost has to happen before there's an answer to the question.
Here's a question from...
We may need litigation before there's...
Yeah. Go ahead, Ann.
Okay, a question from Diane. Will new formatting in law from cyber law, which holds no geo-boundaries, help in establishment of introducing greater legal precedent and unification in environmental law internationally? Kristin, you want to take that?
Cyber law will, I'm not sure that cyber law will help. Say the question again.
Sure. Will new formatting in law from cyber law, which holds no geo-boundaries, help in establishment of introducing greater legal precedent and unification in environmental law internationally?
Well, I might have to defer to Charles on that one, but cyber law is really a beast of its own, and it does actually see boundaries. I mean, each country sort of deals sort of individually with cyber issues and imposes its own restrictions. I mean, that's where you can see like sort of disconnects between sort of the ability to, have Chinese citizens see your YouTube channel. So I don't know. I mean, Charles, do you have a thought on that? I kind of don't think, that environmental law, might be influenced by sort of the global commons a little bit. I mean, it has been, but I'm not sure cyber law is going to be, instrumental in that. What do you think?
Well, cyber law is not my area of expertise, although I have colleagues here at University of Maine School of Law who do it. We actually have a whole Institute of Information Privacy. It is a very hot area among our law students. It's an early area of development. There are draft treaty instruments being considered right now across various areas of cyber law. And I have to assume that it's going to touch on every substantive area of the law that we are thinking about, exploration and beyond. Yeah, David's got his hands up.
Yeah, and I think the answer to the question is yes. And I think the reason why the answer to the question is yes is that as soon as there's a commercial reason to do something, legal protections are put into place to protect that. Cyber law is an interesting area, and I do a lot of intellectual property law, where everybody wants to develop technology and have it protected so they can monetize it. So the law enters in so that there's areas where there's protection of intellectual property rights. And I do think because intellectual property rights is paying for most of private space exploration, that those precedents set usually by contract will come into play.
So this is interesting. This is a sort of a follow-up on that question. Peter Johnson just wrote in saying, Dave, a lot of exploration is for data, but a lot is also directed towards economic returns. How does the law of space, et cetera, apply to mining?
At the moment, that's the purpose of the Artemis Accords, because it's the same with the law of the sea. You can talk about deep sea mining just as easily as you can talk about mining the moon and extraction of, for instance, asteroids. There's an asteroid coming towards Earth that's supposed to be worth more than the entire global economy because of its presence of metals. The reality is that it's still open season. It's still the Wild West. If you can get the money to do something and go and mine materials from the deep sea or the moon, at the moment you can still do it. And there isn't a legal regime in place to say you can't. There might be. We're getting there, but then you get these loopholes like you do with the Titanic, where you have jurisdiction. I can tell an American company or David Attenborough what to do, but I can't tell David Concannon what to do. And look, that's why I'll never be unemployed, honestly.
Okay, so we have a sort of a comment from Greg Harris. As more and more tourists / explorers participate in adventure travel in some unstable political jurisdictions, I suspect their international law and kidnapping will become even more prevalent. The legal and non-legal avenues for retrieving kidnapped persons, including through diplomatic channels and back channels, can be pursued. Also of interest are the legal issues related to home country insurance policies and the potential for them becoming voidable by traveling to certain countries or jurisdictions. In addition, there are a myriad of legal issues associated with obtaining and making claims under kidnapping and ransom insurance. It's the kind of insurance you really need to know you can rely on when you need it. No time to squabble over terms and conditions once you're kidnapped and imprisoned. Does anybody have a comment on that one?
It's a good observation. It brings me back to piracy in a practical sense that I was involved with for a while. If you think about maritime piracy in the Gulf of Aden, so around Puntland, which is where Somalia comes into the right there, a lot of that pirate activity is directed out of Puntland, or it's managed out of Puntland, and there are cartels in the Middle East that fund this kind of activity. And when the pirates get a hostage, and they will take that hostage and move that person from one group to another across Somalia, Puntland, and beyond. And there are lawyers. There's one law firm in particular, a British firm, that specializes in delivering ransom and do the negotiations to get those people back. And a lot of it does have to do with insurance and so on. And if you work in conflict zones, if you're doing exploration work in conflict zones, the commentator is correct. One has to pay very, very close attention to that. David had his hand up. David, you had a
Yeah,
thought?
I do a lot of work for insurance companies in this area. And the reality is insurance companies are in the business of insuring against risk. And insurance companies are also in the business of making money. So they don't necessarily want to pay off. They don't want to pay for your mistakes. So you do have to read the terms and conditions, because the terms and conditions often say we are not going to pay for your mistakes, but we will insure a certain amount of risk. But you have to mitigate against the risk. It's also your responsibility. And we won't insure against intentional acts. And we won't insure against you going to certain places. And it becomes a risk management situation where you have to decide, as the person going into a conflict zone, if this is a risk you want to take, recognizing that you may be beyond help, like in Antarctica if you fall into a crevasse, and recognizing that somebody may not be there to help you, and trying to pay for somebody else to help you if you need it. And it's a classic example that explorers face before they make a determination. That's why planning for an expedition is so important. You have to know what you're doing before you go, before a problem arises, before you need somebody's help.
As you plan your expedition, you may think you're not entering a conflict zone. And when you get there, you're in a conflict zone. That happens.
Right.
So Mark Alio from the New England chapter asks, first of all, he says, great presentations all. Care to share your view about the state of international treaties and law today, especially those relating to the environment and notions of sovereignty, and specifically the roles of the US, Russia, and China?
Wow. Big question. Who wants it? Kristin, you're lit, or am I lit? First of all, if this is the Mark Dalio that I think it is, Mark, I'm very sorry for the loss of your brother. And if it's not the Mark
I'm sorry,
Dalio,
it's a different person. No.
it is. Okay, good.
I do have to say that it is a different
larger
Mark, and all our hearts
Okay.
go out to Mark, because it was just an absolute tragedy. Sorry to have to bring that up now, but
No,
this is a different Mark. Mhm.
So with, Russia, China, the United States, some of the big players are really looking out for their own interests. The law of the environment's interesting because there's a huge disparity between the haves and the have-nots in the world and how they view environmental issues. And there's a huge disparity between the industrialized nations and the non-industrialized nations about how they view the environment and their environmental obligations. And you really need to be aware of it, and you really need to navigate those issues. I don't want to punt on the answer to the question, but this is one of those things where the question comes up, what do you want to do? How do you want to do it? Where do you want to do it? And who are you going to offend? Then you have to look at it in that light.
And just to follow up, it's a very good question. States enter into treaties when it's in their interest to do so, right? There's this notion of what we call in international law pacta sunt servanda, which translates to the sanctity of the treaty, right? The treaty or the contract is to be performed in good faith. Now, does that always happen? Well, yes, it happens, as long as it's in the interest of the states, the parties to the treaty, to do so. And then that's where, when we see treaties, it doesn't matter what the subject matter is, but treaties between some of these major states, big states, major powers, may not be observed in the pacta sunt servanda manner that we would like, and that we would expect. And we've seen that. We've seen that with the environment. We've seen it in international human rights. We see it in a lot of areas.
See with the Titanic.
Yes, exactly.
So here we go with something pretty different. What are the laws for archaeological discovery? Does the landowner own the right to the archaeological discovery, or is there higher international jurisdiction that can take claim to a discovery?
Charles,
Go
you may
ahead.
have an answer too.
Yeah, I think both
The
of us
answer
can. I mean,
would-
the general answer is that will depend on the country where the discovery is
Right.
made.
Right.
Let's take Greenland, for example, where we're doing some work and interact with archaeologists. Nobody owns land in Greenland. Nobody. The land in Greenland is owned by the whole population, which is indigenous. Anything found, right, on land anywhere in Greenland that is of archaeological significance, if it's not looted and stolen, right, requires all kinds of permitting to remove it, and the government of Greenland is going to have first take and first dig, so to speak, on that. David, did you?
Yeah, Charles is right. I was going to say that it really depends on where you are, because in international property law really depends on the type of legal system that your country follows. In the United States and England, for example, property law goes back to the Magna Carta, to the signing of the Magna Carta. And property law says that whatever is buried in your land belongs to the landowner. So if I lose my watch and it's in the grass, it's my watch. If it's buried in the soil, it belongs to the property owner. And this is one of the issues with the sea. Nobody owns the high seas. So if you lose a shipwreck, you lose a ship and it goes to the bottom of the sea, it still belongs to the original owner 2,000 years later. Unless in some situations it's buried in the subsoil, and then it could belong to the owner of the soil. So, and this is why it's an interesting puzzle to solve. But in other places like Greece or Denmark or Greenland, where the land belongs to everyone, whatever's buried in the land belongs to everyone. So,
This question is interesting. It reminds me again of Gertrude Bell. That first Antiquities Act in 1922, Mesopotamia becoming Iraq, King Faisal, and so on. The reason she drafted that act was because these antiquities, these archaeological artifacts, were being removed from this new country that she loved, from Mesopotamia, from Iraq. And that started this whole movement, this trend, I should say, towards the registration and compliance with national antiquities archaeological artifact acts that this questioner is asking about.
That's why
what's
it was so
also interesting
important
about
to
this,
listen to.
Anne, is,
Go ahead.
let me interrupt for a second. What's also interesting about this is it actually applies to issues like the moon and
Yep.
mining on the moon. Who owns the moon? No one. Who owns Antarctica? Kristin talked about that, and it was a terrific part of her presentation. Different countries said they owned it, but then in reality, when they couldn't extract anything from it, a lot of different countries agreed to cooperate over it. But this issue of who owns the moon and who owns the deep sea, and the answer is no one. Who can then extract things from that? The answer to that question is who wants to control it? Not who owns it, but who wants to control it.
But I think to that point, real quick, the Antarctic Treaty, I think one of the reasons why it's, remains stable is because, other than sort of some of the exploitation that's happening in the seas around it, there's this whole question of whether there's minerals or not. And so far, the whole ability to mine in Antarctica was sort of also put, in deep freeze mainly because it was just infeasible. It was so expensive. But if that sort of the math changes on that, I mean, that's the predicted downfall of the treaty is once there's something valuable on land that is worth going after, all bets are off, really. And I think, the fact that there's a lot of parties actually will help stabilize it. But, there is, once there's, like you said, once there's something to grab and if it's valuable enough and it's accessible enough, then, it totally changes the dynamics of what people are willing to do under sort of a treaty agreement.
Great.
So we just got another question in sort of in that same vein, and that's from our really good friend and partner at the United Nations, Francois, who asked, David, when you say deep sea, what do you mean? Are there no provisions for regulating mining in the area?
There's the deep sea.
The answer to the question is, my definition of the deep sea is consistent with the International Convention on the Law of the Sea, which is the high seas. And the answer is no. There are no provisions for that. Not any that are enforceable. The Titanic agreement that was negotiated by 4 countries puts the Titanic on the continental shelf of Canada. Well, that's like saying that Tallahassee, Florida is on the continental shelf of Cuba. It's just not. It's stupid, but it's something that people put into play without thinking about the international ramifications of extending the continental shelf of Canada and the fisheries and the Grand Banks and everything else, because you want to protect something you don't control. And so, no, deep sea mining is a hot issue right now. And it's a hot issue in the United Nations. And at the moment, in my professional opinion, it's loot and scoot. Take what you want. Yeah. But Charles, go ahead.
Just to add, David, and to your observation, there is the International Seabed Authority, and there's, in addition to the authority, there is the enterprise. There is a whole regime of contracting and so on, and there is deep seabed mining going on, and all of this is within the context of the seabed below the high seas being the common heritage of mankind out of the UN Convention on the Law of the Sea, very, very explicitly. So you have that tension that you're talking about, right? And that led to issues with the United States signing and then not ratifying the UN Convention on the Law of the Sea under President Reagan, right? The commerce versus the notion that so much of on the seabed is a common heritage of mankind, and that's still being worked out, as you say.
But it's a question where commerce wins, and at the moment, commerce wins, and you still have the international law of the sea, but the Norwegians are doing a lot of the work in the deep sea, and I don't know where they fit into that equation. But if I want to do something in the deep sea, I charter a vessel for a client from a country that's not a signatory to these laws, so that they can do whatever they want, and we leave from a port where we don't have a conflict, and there are ways around it. I mean, that's what I do for a living. So there are ways around these issues that are talked about in the United Nations, and it is an issue, and it needs to be sorted out. But I'll say this: one of the things I dislike intensely is when organizations, government organizations, international organizations don't involve the private sector in their discussions. And I remember when I was general counsel of the X Prize Foundation, present for the first private space flights of Spaceship One, a couple hundred people were in attendance. A lot of them were from NASA and JPL and other places. And they really looked down their nose at the private sector that was putting a ship into space. Those same people haven't launched the spaceship in years. Their resumes are on the slush pile at Blue Origin and SpaceX, and they don't have a mandate or really anything to do. And so if you want to talk about what should be done, you should talk to the people who are doing it rather than just the governments. And coming from the private sector and coming from that angle, I love it when people sit at a cocktail party in Washington, D.C. and talk about cultural heritage law and write books and law review articles and things like that, but they're not out there doing it. And if they're not out there doing it and they don't know who's doing it, it's just talk. It's just hot air. And there has no application. And it's not going to matter, except to your 6 people that you can fit in a van to go to a meeting. There's my my tirade on that subject. But if you want it to matter, involve the people who are doing it and get their perspective on it and get them to sign off on it, like NASA did with the Artemis Accords.
So I want the viewers to understand the diversity here and the complexity of all these issues. Llewellyn asks, saying that I will comply with all regulations and laws is easy and of course praiseworthy, but in practice, especially in developing countries, can be difficult. I'm aware of countries where there are enacted laws and regulations, but no functioning or responsive enforcement agency who can give you permission. There can be, say, island chiefs who give you permission to explore, film, interview, but the national or regional level agency is just silent. What do you do? What examples can you give? Thanks.
I think that would be a great topic for an entire session. It's something that a few of us, I've dealt with it in Afghanistan and other places, and I see exactly where she's coming from. You know, you go to a place and there's a law in the books, often written by, Western lawyers, and then there's the way things are done, the operational code. And part of being an explorer and working in these areas is that one has to be able to identify which really is going to be applicable that you can work with that will allow you to achieve your goal, your objective with the mission. And it's not easy. We can talk about a range of countries.
Charles just hit a home run. It's really true. I studied international environmental law in Kenya. And ironically, my family and I are watching Long Way Down, which is about riding motorcycles from the tip of Scotland to South Africa. In every country, they have a local fixer that they employ to get them through the borders and get them from A to B on time and things like that. And the only reason I go on expeditions is to answer questions from the authorities, get involved and say, you're not supposed to be doing this. And then I argue with them. But it's really true. The law says one thing, but it doesn't matter in Mombasa or Kigali or Kabul.
Congo.
Congo. It just doesn't matter, because I'm the law. This guy here is the law. The police officer on the side of the road at the checkpoint is the law. And you need to, it gets down to the 3 meters on either side of you that really matters. So
I'm going to take one more question, and this is going to be, of course, for you, David, but after that, I'm just going to tell you some of the other questions that have come in that we will go to revisit again in some of the upcoming programs that we'll do together. Sub-teams are planning on continuing to visit the Titanic. If valuables are taken, who owns them? Does a visit have to be recorded? If not, what repercussions would there be if a treaty is violated? How will anyone know if any treaty restrictions are broken? And that's from Frank on YouTube.
Okay, so there's two parts to my answer. First of all, I'll be with the next expedition to recover artifacts from the Titanic. Forget about international treaties. They don't apply. I don't care what anybody says. I don't care what you read. I don't care what they want you to believe. They do not apply. The only two things that matter with going to the Titanic are, if you're going to recover artifacts, what does the federal judge in Virginia think about that? And are you doing it pursuant to the legal rights that one company currently has, and they may not have forever? It's all that matters. Secondly, the other reality is we're not at the Titanic right now. And if somebody wants to go to the Titanic, as two expeditions have, without anyone's approval or knowledge, and recover artifacts as one did, you shouldn't do that. But honesty is the fear of getting caught. And the rogue expedition that went out there in 2002 that recovered portholes and things like that, they went into England. They got all the English authorities were given the name of the ship, photographs of it in port, the name of the participants, and they did nothing. Zero. So I'm kind of dubious and skeptical about enforcement, but there's no treaty that matters, that protects the Titanic. The only mechanism legally that protects the Titanic is Judge Rebecca Beach Smith in Norfolk, Virginia. And her opinion is the only one that matters.
So just a few more questions that we're not going to answer now, but I just want you to be aware of for the future. Jenny is asking, sunken German warships off the coast of Norway with crude oil in their cargo, who's liable to clean up these wrecks of 80 years old in these waters? Let me tell you that this is already upcoming. We have something planned on this, and it's not just off the coast of Norway, it's all over the world. And we'll be discussing that later on in time. Other people are asking about space junk and debris up in space, who's responsible. We'll have a special segment on space as well. Another person is asking, if someone finds Andrew Irvine's Kodak camera on Mount Everest, do they get to keep it, monetize it, remove it from Nepal, China? So all of these things are questions that we're going to get to. And this is one of those, stay tuned, same time, same channel. We'll just give you a different date. I just want to say thank you to all of our panelists tonight and to all of our viewers, because you have viewers tuning in from all over the world, from South Africa, from Spain, from Ireland, just about everywhere you can think of, from Belize. And I want to say thank you again to Kristin, to Charles, to David for putting this all together. It's really incredibly special. I just want to also tell you that next Monday night, we're going to have Jill Heinrich as a moderator. The topic is underwater ice age discoveries beneath the Yucatan, exploring La Mina. That's with Sam Meacham, Dominique Risolo, Edward Reinhardt, and quite a few other scientists that have been working on this incredible project that dates back 11,000 years. Who it belongs to, we'll find out next Monday. Take a chance to say goodbye to everyone. And again, thank you all for being a part of this very special evening.
It's been
Thank you very
fun.
much. Good to see you. And thank you again, Anne.
And you're a rock star. Thank you for putting this together and all your hard work. You're amazing.
Happy New Year, everybody. And thanks so much for helping out here.
Good
Good
night.
night,
Happy New Year.
everyone.